Okay, let's talk about the Peet test for Aboriginal rights. So, in the Peet case, Supreme Court of Canada established the test for identifying Aboriginal rights. A claimant will have an Aboriginal right to engage in an activity, the court said, if that activity is an element of a practice, custom, or tradition integral to the distinctive culture of the Aboriginal group claiming the right. So to give rise to an Aboriginal right, this custom tradition must have been a defining feature of the culture in question and must have truly made the society what it was. It must be grounded in the practices, customs, and traditions of the claimant's community from pre-contact times, even if the activity was interrupted for a time or was influenced by European culture. Activities that all societies share or that are incidental to the group claiming the right are not sufficient. So under Peet, a court presented with an Aboriginal rights claim must first identify the nature of the right being claimed. So to help frame this analysis as to what is the nature of the right being claimed, the court will consider 1. The nature of the complainant's action, which was done pursuant to an Aboriginal right, 2. The nature of the impugned Crown action, and 3. The practice, custom, or tradition that gives rise to the right claimed. Once the nature of the claimed right is established, the court must determine whether the activity is integral to the distinctive culture of the claimant's community. If the activity is integral to the Aboriginal's claimant's distinctive culture, it will then rise to the level of an Aboriginal right under Section 35 of the Constitution Act of 1982. If not, said activity will not enjoy constitutional protection. Aboriginal rights are not absolute, and they may be infringed pursuant to the test from the Sparrow case. So, Section 35 Aboriginal and treaty rights are not part of the Charter of Rights and Freedoms, so they are not subject to legislative override under 33. Section 1 of the Charter allows governments to justifiably limit a charter right, and Section 33 establishes the notwithstanding clause, which allows governments to pass laws notwithstanding their impact on certain charter rights. But Section 35 is not part of the Charter. So, although neither Section 1 nor Section 33 may be invoked to override or diminish Aboriginal or treaty rights, these rights are not absolute. Under certain circumstances, as shown by the Sparrow's two-step test, can justify an infringement of the Aboriginal right. This test is contextual, which means the standard of justification varies with the facts of each case. Sparrow test, 2 steps. 1. The complainant must establish that the impugned law has the effect of interfering with an existing Aboriginal right. So here the courts will ask questions to understand the characteristics and scope of that right, and in what manner the law might have infringed that right. And the courts seek to determine whether the purpose or effect of the impugned law unnecessarily infringes the claimant's ability to exercise their Section 35 right. If so, the court will find a prima facie infringement of that right, and then the Crown will bear the burden of justifying that infringement. And the Crown must then justify the infringement, if it is shown to be an infringement of that right, by showing that 1, the law has a valid objective. So these valid objectives need to be compelling and substantial. For example, conservation, natural resource management, public safety, all valid. However, public interest is not sufficient, too vague, too broad concept to justify limiting a constitutional right. 2, the limit is justified in light of the principle of the honor of the Crown and the Crown's fiduciary duty to the Aboriginal people. So this analysis attracts questions like whether the infringement is necessary to achieve the Crown's purpose, whether the law is minimally impairing on the protected right, and whether fair compensation was made available for an expropriation of land, or whether the Aboriginal group was consulted with respect to those regulatory measures. If a court finds that the infringement is justified, the law remains valid and applicable to that Aboriginal group. If not, the impugned law would be found to be contrary to Section 35(1) of the Constitution Act of 1982 and of no force and effect as it relates to the Aboriginal group whose rights were infringed. So the courts use the Sparrow test to justify infringing Metis rights, treaty rights, and is the basis of the test for infringing Aboriginal title. And in RV Coat, important point, the Supreme Court of Canada confirmed that the Sparrow test equally applies to federal and provincial laws. Thank you for watching my video. Please do me a big favor and hit that like button and subscribe to get more videos on law school and NCA exam prep.